Legal dictation at the rate 100 word per minute for all the high courts. Last study. Start. It is thus clear that power of the magistrate under section 156 within bracket 3 of the code for directing investigation may be discretionary, but the same is to be exercised judiciously. Stop. The discretion, therefore, has to be exercised by the magistrate on his own from the facts stated in the complaint and not upon the view of the police, and that too, not arbitrarily. Stop. So far as the police is concerned, it is under a statutory mandate of registering report under section 154 of the code as when the information is given regarding commission of a cognizable offence and dereliction of police officer in discharge of the above statutory duty cannot be taken lightly, but deserves to be taken in a more stricter manner. Stop para. In the case in hand, the magistrate though has held that a civil dispute between the parties, was pending in the court of civil judge, Farukhabad, but simultaneously he has permitted the revisionist to file a complaint, meaning thereby, he has not found that the information is incorrect or appears to be false, or that the information does not constitute a cognizable offence, but impressed with the fact that the police does not believe the information of the revisionist, and that it has taken proceedings under sections 107 and 116 of the code. He has rejected the application, though he has made it open to the applicant it to file complaint. Stop. In view of the Ram Babu Gupta within bracket supra, he could have treated the application as complaint under section 190 of the code and proceeded accordingly. Stop para. I therefore, while having no doubt on the exposition of law that power of magistrate under section 156 within bracket 3 of the code of discretionary, but is clearly of the view that it has not been correctly exercised by the court below in the case of hand, and the order impugned is erroneous and is liable to be set aside. Stop para. However, this matter does not end here. Stop. It is true that for an orderly society, the importance of an effective and efficient police force dedicated to the public service is of utmost importance and is the necessity of the time. Stop. It is a matter of common knowledge that the people run from pillar to post after occurrence of a serious crime for mere registration of the report, but the concerned police authorities fail to realize trauma and harassment of such people and simply ignore the observance of their statutory duty, despite of the same being declared mandatory and is the law of the land settled by the apex court. Stop. Crime detection and adjudication are two separate though inseparable beings of justice delivery system. Stop. The former is the basic obligation of the police and latter is in the hands of judiciary. Stop. Though the code provides for an alternative remedy of approaching the superintendent of police and thereafter to the magistrate concerned under section 163V, but such remedy, instead of providing any solace and relief to the harried lot, on the contrary, is adding to their sufferance due to persistent lackluster attitude of police compelling a common man to run from one authority to another for a simple cause of registration of an information constituting commission of a cognizable offence, so that the police may make investigation according to the procedure